Now, we do want to get right to some breaking news this morning out of Moscow, as classes are canceled for the University of Idaho today following the deaths of 4 students.
Nicole Hernandez live in Moscow right now. Nicole, you've been there for an hour or so now. What are you hearing from police this morning?
So, Tim Channing, what we know right now is that police do still have this house here blocked off with crime tape, investigating here. We have one person also kind of manning the scene, making sure nobody messes with the area. But what we know is yesterday, this house right here is where police found 4 bodies. And later that day, University of Idaho confirmed that they were U of I students there. So take a look at this breakdown here of the timeline that we have of how things happened. About 1 p.m., we heard reports of a murder investigation, or excuse me, homicide investigation near the college campus. An hour later, the school put out an alert on social media. It said Moscow PD is investigating a homicide on King Road. They asked the community to stay away from the area and shelter in place as a precaution. Around 3 in the afternoon, Crime 2 arrived in Moscow. Neighbors said most people living in this area are part of U of I Greek life or are students. At around 5 in the evening, the Moscow Police Department confirmed they had found 4 people dead. But it wasn't until late that night that they confirmed the victims were students. The University of Idaho also said Moscow police do not think there's any active threat at the moment as they continue their investigation. And again, classes are canceled today for University of Idaho students. They will resume classes tomorrow. In Moscow, Nicole Hernandez, Crime 2 News.
Now, last night,
What's going on, everybody? Welcome back to the LTL podcast. It is August 25th. This is the second show, and it is episode 68. I want to welcome everybody into the live chat. If you're watching live, feel free to chat there on the right-hand side of the screen. And if you're watching this on a replay, comment after this post. And let's see some hashtag replays down there in the comments. I see a lot of people filling in here. It's good to be back here for the night show. I know I've been streaming a little bit earlier during the day just so I can get some work done on other projects that I've been working on behind the scenes. I've been actually following a lot of the Anthony Farah Timepiece Gentleman saga lately and getting you some all updates on that as well. If you saw my parody video that dropped today, which was pretty hilarious. And I also dropped a YouTube short just about an hour ago, which has been pretty good. And I'm going to keep following that case because we're seeing a lot of information about that. And I know that you're all curious about it. But tonight we're here to talk about Bryan Kohberger. And we know actually what happened the other day. Bryan Kohberger has waived his right to a speedy trial. And this is going to bring pretty much this case right now to a grinding halt until we have the next hearing where Ann Taylor said that she's going to put the date out as to when she wants to schedule for trial. I'm going to tell you, it's probably going to be a year, at least a year. So we need to buckle in, sit back, and see what happens. And the thing that we need to continue to do here, just smashed my hand. What we need to continue to do here is support the victims' families in this. They cannot be forgotten through this process. We need to continue to serve that love to them, give them love and support. And hopefully, we get this case to go to trial in a decent amount of time, because the thing that scares me is that as trials tend to go on, and if there's any type of length in between a trial date, people can forget things and evidence can become stale, and they may not remember what they specifically said or saw or heard in a specific moment, talking about witnesses. And that's the thing that scares me when these cases get dragged out, or they need to be scheduled later. Again, people tend to forget the freshness of details. I mean, you got to think right now, we're almost a year. We're almost a year to when this happened. We're close to being almost a year. So things now and what they were a year ago, you may not remember every intricate detail. So again, if this is another year, this could be 2 years out. It could be 2 years out till we actually see this case actually take shape in a courtroom, but it remains to be seen. So let me just read this recap, this headline. We're going to get into the video this evening. I do have the Peter Tragos video where he just read through all the recent documents. I know you'll be interested. I'm interested to see what he's going to say, because he's an actual lawyer and I love his legal representation and his interpretation of these documents, so we can understand them a little bit more in more of a layman's term. He does a really great job with that, and just get his insights as to where he thinks this case will be going next. So Bryan Kohberger is the suspect charged with the murders of the 4 University Idaho students, has taken a significant legal step that has altered the course of his trial. The victims, Ethan Chapin, Xander Canodal, Madison Mogan, and Kayla Gonzalez, were brutally stabbed to death in an off-campus home in Moscow, Idaho. Initially scheduled to begin on October 2nd, Kohberger's trial has been delayed indefinitely after he decided to waive his right to a speedy trial. This decision was covered by ABC News, CNN, and Fox News, as left many wondering about the implications. The waiver was accepted by Judge John Judge, leading to the postponement of the trial without a set date. I love that judge's name, by the way. Kohberger's defense attorney, Ann Taylor, cited the need for more time to present their case as the reasons for this move. The defense also aims to retain the September 1st hearing date to challenge the grand jury indictment. And essentially what they want to do is they want to reset this case. They want to go all the way back to the beginning. If they get the indictment thrown out, which I don't think is going to happen, just judging the way that Judge was in the hearings these previous 2 days. If we go back to when he was asking about the alibi, and he said the said alibi, and then he put forth the schedule and said, this is going to be the schedule. We're heading for an October 2nd date. But let's keep this in mind, friends. If this gets pushed out, if this indictment gets squashed, what's going to happen is they'll refile in the indictment and they'll have to start over. The reason that Ann Taylor is trying to do that now is because, in my opinion, she has now been able to see, with all the hearings that she's used and all the motions that she used to slow this down, and rightfully so. She's his defense lawyer. This is her job. But to slow this down was to see evidence, to get her eyes on the evidence. And what she's hoping is, in my opinion, if you go back and you squash the indictment, they re-indict, which they'll probably get because they have enough for probable cause. She's probably hoping that she can get witnesses on the stand to speak with them, to cross-examine them pre-trial. So I'm going to go on to read here. The connection between Kohberger and the crime scene was established through DNA and cell phone records, with a probable cause affidavit linking him to the murders. The victims' families have been through immense pain, and they expressed a mix of relief and anticipation for justice to be served. The suspect's surprising decision to waive extradition to Idaho and his claim for looking forward to exoneration added further layers of intrigue to this complex case. Bryan Kohberger's role as a teaching assistant at Washington State University during the time of the murders adds another dimension to the story. With the trial time now uncertain, we will explore the implications of this delay and the emotional impacts of the victims' families and the community. So let's pull up a video here from Live News Now. We'll get a little bit of a recap as to what happened in the courtroom, and then we'll take it away with Peter Tragos to hear what his opinion is and his legal interpretation of what's going on in this case.
We want to get to the latest in the Bryan Kohberger trial. That trial going to be delayed after all. Kohberger waived his right to a speedy trial during a court hearing just yesterday, pushing back the trial start indefinitely for now. Joining us to break down what this means is legal analyst, friend of the program, Jacqueline Goodman. Jacqueline, of course, a lot of people that we have talked to, including yourself, expected that this trial would be delayed. But are you surprised that it took so long for this move?
No. I think that we all did really expect that he would waive his right to a speedy trial. And in Idaho, they have a right to a speedy trial within 6 months of the date of the arraignment. And so they do have time to figure out whether or not they think that's the right strategy. Generally speaking, if somebody's out of custody, they're going to be waiving their right to a speedy trial to allow their attorney time to prepare. But when you're in custody, that's not always the case. And so, it takes a little bit of time to figure out whether or not you really have to waive that right.
Can you just explain to our viewers a little bit the terms that a speedy trial requires, just so we can get a better understanding as to why Kohberger denied this right?
Yeah, so the United States Constitution requires that we all have a right to a speedy trial. So you can't just linger in custody, generally speaking. So there are some notable exceptions, Guantanamo being basically it, where folks wonder how it is that the Constitution be suspended. But in our everyday lives, the states have to comport with that requirement, and every state has a different way of doing it. And so in the state of Idaho, they allow a defendant a right to a trial within 6 months, and that is enough to comport with the constitutional requirement and the state statutory requirement, the state constitution requirement in Idaho. And so the defendant has that right, and the defendant can waive that right. What's interesting about Idaho, which is different from the majority of other jurisdictions, is that once you waive your right to a speedy trial in Idaho, you sort of waive it for good. It's not that they can just languish in custody eternally, but it's really one waiver. And so that's why you see the judge taking particular pains to make sure that he fully understands the rights that he's waiving. And it's a pretty big decision, whereas in other jurisdictions like in California, where I am, you waive that right incrementally. So it's not that big a deal when you say you can bring me to trial in 10 extra days, and we'll talk about it again then. So in Idaho, it's kind of a big deal.
Is it still too early to speculate when this trial could start?
It is actually a bit early to speculate on a particular date. So as long as we're not, in Vegas, I'm not going to be placing any bets on it. But what I can tell you is that in a case this serious, this is a capital case, and it's nothing to make light of. Really, the defense, in order to make sure that they're providing us an efficient and complete defense, that they're looking at every possible avenue for a possible acquittal, they've got to do their job. And so that takes some time. It takes time to do investigation, and it takes time to find experts and determine the theory of the case and the theme of the case, and get ready to really put your best foot forward, because you literally have somebody's life in your hands. So when they push the trial back in increments of 37 days, for example, I don't think anybody takes that all that seriously. But it's hard to say whether this is going to be months or years. I know that the victims' families have been pretty vocal about their concern that this would go on for years and years and years. And really, that's unlikely in this case.
Jacqueline, there was a motion hearing just last week, and when the judge ruled that this trial would not be delayed. So why all of a sudden the reversal?
Well, because the defendant at that time hadn't yet waived his right to a speedy trial. And so the court was having to make difficult decisions and make sure that he had the lawyers on track to get this trial to the jury in a timely way. And this now, given the good cause that Ann Taylor, his lawyer, has shown, and the need that he has in this very serious case for more time to prepare an adequate defense, there's no way the judge was going to deny him that.
You did mention briefly the victims in this case. I'm going to pull up some photos of those 4 victims and the fact that their family is very concerned right now because they don't want this trial to last 4 years. They're just trying to get some closure. Does the judge consider what the family is going through when it makes this decision about delaying the trial?
Yes. After 260 years of jurisprudence, generally speaking, criminal defense cases or criminal cases were the government trying to take the liberty and even the life, as is in this case, of a citizen. Here, though, what we've seen is some of the effects of what we call Marsy's laws, or laws that are designed to give voice to the victims in these cases. So those kinds of ideas really kind of change the dynamics of a criminal case. But what happens now is that virtually in every jurisdiction, they have these kinds of protections. The victims in cases do get an opportunity to be heard, to know about things that are changing as these critical stages come up and these changes occur. They get notice. Now, statutorily and sometimes constitutionally, they're right to have notice about what's happening. And so judges do listen to what the victims feel and what they're thinking, and the courts will, take that into consideration when they're making their rulings, but doing so in the context of the other considerations in terms of what is fair to the defendant and what is necessary to protect the public interest. So, the judge is definitely going to be listening to what they're saying. And that's for that reason, I don't expect that this case, and other reasons, quite frankly, I don't expect this case to go on and on and on for years like they're afraid. And I don't think that it's going to be something that happens in a month either. I think it's going to be somewhere in between. My guess would be maybe a year from now or less.
Finally, Jacqueline, now that this trial has been pushed back, do you expect that the flow of information is also going to stop? I mean, we got a lot more details as these hearings were approaching these past few weeks.
Well, I don't think that the flow of information is going to change, other than the fact that now the timeline is longer. And so lawyers have more time on each side to be bringing motions and to be litigating. And so you may not see something happening every day, but you're still going to see, I think, a lot of litigation in this case. It's high profile. It's something that the entire community is watching. And I think the lawyers are quite well aware of that. They're going to be put to task. I think the judge is going to hold them on a tight leash. And I think they're going to have to be litigating this case pretty quickly. And I think you're going to see a lot of information coming through.
Jacqueline Goodman, criminal defense attorney, friend of the program, we thank you so much for joining us here at Live Now from Fox and being one of our go-to people when it comes to dissecting this death penalty case against Bryan Kohberger. We look forward to having you again soon.
All right. I actually didn't mind her interpretation. And by the way, there's some new documents that I'm going to pull up here in a second. We can breeze through them here in a second. Give me 2 seconds. Oh, let's see. Let me just look at something really quick. Okay. Let's pull these up before I pull up the lawyer you know. Before the lawyer you know. This one here. Let's do this one first because I think this is this will be interesting. And I can kind of see what she's going to use. I can already see, because someone pointed this out the other day in court. But let's go here. This is a motion to remove cameras in the courtroom. I am completely against this. I think it's a bullshit move. I think that we need transparency and we need to know what's going on in that courtroom by the way that people are acting, by the way people are moving, facial expressions, smiles, laughs, sighs, whatever, sadness. We need to see everything. We need to see everything. But Ann Taylor wants to block this. Ann Taylor doesn't want freedom of speech. She's against the First Amendment, in my opinion, and wants to block every single thing that she can from this case. Okay, so it says, comes now Brian C. Koberger through the attorneys and records and files in this motion to remove cameras from the courtroom for the remainder of the proceedings in this matter pursuant to his right to a fair trial and effective assistance of counsel guaranteed him by the 6th and 14th Amendment of the United States Constitution, Art 1, Section 13 of the Idaho Constitution. Motion to remove the cameras in the courtroom. Let's see. Cameras wielding courtroom observers have failed to obey the court's June 27th directive to cease focus exclusively on Mr. Koberger, the expulsion of cameras from future proceedings. The question presented by this motion is whether Mr. Koberger faces deprivation of his right under the 14th Amendment to due process by televising the broadcast of this trial. I'm not going to read too much into this here. Nearly 2 months ago, on June 27th, I'm going to probably paraphrase this and just pick out things that I want to talk about, so just bear with me. Nearly 2 months ago, on June 27, 2023, the court warned press observers not to focus strictly on Mr. Koberger and show a wide shot of the courtroom if they wish to continue filming court proceedings live. Fox News, Brian Koberger, judges issues warning to media at start of hearing on Idaho murders, June 27, 2023, available at, and there's a hyperlink there. Press observers had thus far failed to comply with court direction as the continued publications of images such as shown below continues to the present day. Those photos are blatant violations of the court's directed to cease focusing exclusively on Mr. Koberger in their own right and later upheld to articles with blatant sensationalistic and prejudicial headlines and context of the rightmost of 3 photos above being used in an August 22nd, 2023 Daily Beast article. Reporter says Koberger's creepiness with women goes back to high school. Oh no, not 3 photos. Not 3 photos. Available at, and this is the hyperlink. Further, the cameras continue to exclusively focus on Mr. Koberger, provides funding for observers and purposely analysts on social media who are not bound by notions of journalist integrity and who have potently and even greater reach than traditional media outlets. So she's basically talking about TikTokers, YouTubers, Facebookers. I'm sounding like a boomer right now. Those damn YouTubers and Facebookers. These images and videos are plainly observed on social media platforms such as TikTok, and X, formerly Twitter, and posts such as oh my God, this is crazy. As the press itself notes in a court's June 22nd, all right, let's see. More, it's about Fox Seattle. There's another hyperlink. Indeed, in such parallel has drawn in the defense prior memorandum on cameras during the hearings, yet the camera wielding courtroom observes remains undeterred. The chief function of the judicial machinery is to discern the truth. The use of television, however, cannot be said to contribute materially to the objective. Rather, it is amounts of injection of the irrelevant factor into the court proceedings. Oh boy. Still with me, everybody? Dr. Bob says, hey. Hey, let's not insult the boomers. I know, right? So let's see. Michelle's asking, do you think counsel has enough time to thoroughly prepare strategy given the prolonged time to look and receive all discovery item requested, perhaps some bearing on decisions to delay? Well, that's why they delayed. That's exactly why they delayed, because there's no alibi. There's a mountain of evidence, in my opinion, against Koberger. I think that they have a lot, again, we've only seen in the public 10 to 20% of the evidence is going to be shown in this trial. I think there's a bunch of damning evidence behind the scenes that we haven't heard or seen yet. There's no alibi. If he had an alibi, then if you're a free man and you're being held for a quadruple homicide that literally is going to be followed by the death penalty if you are proven guilty, why are you not screaming at the top of your lungs with your alibi? I was with X. I was with here. I was with this person. I was here. Here's the receipt to the gas station that I was at. Here's my plane ticket. I was in whatever, Vegas. I wasn't even in the area. I drove to California. Here are my receipts. Here's the person I was with. I was with A, B, and C. None of that was provided. None of that was provided. And then when the deadline got set to prepare for Kohberger to have his alibi and have those witnesses in his documentation so the prosecution could speak with those witnesses, what did he do? He waived his right to the speedy trial. So he's going to sit in prison now, probably a year. If I'm innocent, I would want to get to fucking trial pretty quick and put it all out there and say, hey, I'm innocent. I wasn't here. I was with this person, or I didn't do it. I was in this specific area. Someone took my phone and whatever you need to do to defend yourself, to prove the truth. But in my opinion, they waived the speedy trial to slow it down more, to come up with an excuse, to come up with an alibi, because they don't have one right now. And that's why this kept getting slowed down and slowed down. Like the whole smoke and mirror show the other day with all the witnesses. We're going to plop all these witnesses up there. What happened? Judge wasn't hearing it. He wasn't hearing it. And just like the whole thing the other day during the speedy trial waiver, when Ann Taylor stood up and said, oh, these two FBI agents came to one of my witnesses and that's intimidated. And Bill Thompson stood right up and said, hey, we were aware of it. And the reason we were aware of it is we got notice that this particular witness was out on a social media platform talking about her testimony and recanting things that she talked about. And I had questions about her from the beginning of all of this. When someone asked me if I had a bachelor's degree, I'd be pretty damn proud of it. They asked her, when did you receive your bachelor's degree? And she said, I don't know what year it was. Now, granted, I understand that she's done some pretty damn good things for some cases out there, but to me, it's a little questionable. Why would you pull back? And then because the FBI is involved in this case and they're lead investigators now, they went and talked to her, asked her some questions. Oh, but that's witness intimidation. No, they want to find out what she said, because if she's tainted or she's saying things that she's not supposed to be saying outside the courtroom, that needs to stop. Those are my opinions. All right, as previously been argued, the circumstances present in Mr. Kohberger's case are singular and pose an extraordinary risk to prejudice beyond that posed in Etze. Let's see. The images and videos provided above were taken during a pretrial court proceeding, but pose no less danger. To the contrary, they are gradually poison the potential jury pool and trial, even occurring the number of jurors able to render just, unbiased verdict. To the extent of the television-shaped segment, it can strip an accused of fair trial. Court itself noted that the unrestricted television coverage can be corrosive to non-trial proceedings and preemptively limit the potential for the eventual fair verdict. Let's see here. As such, from where are we going here? As such, from the constituting of the undue and over-restriction burden on the press right of free speech, expulsion of cameras used to flaunt the court's limited directed that Mr. Kohberger is not be the sole focus of images, videos taken. So the sole means to limiting, it's just going into a big legal argument here. Let's see. In addition, the ordinance to excessive force, focus on Mr. Kohberger, same stuff here, it seems. Oh, we have some more. Let's see. They're getting angry that news stations are reporting and showing images from the courtroom that they have permission to do. So you have these clips up here. It looks like 7 KTVB. Judge rules that Brian Koberger's murder trial will happen in October. It's a fucking still video of him sitting there in court. How is that going to persuade anybody? And then this from Law and Crime Network. It'd be great if they had LTL podcast on there, wouldn't it? That'd be great. Idaho murders, judge refused delay. So that's from Law and Crime Network. More legal conclusion. The press have failed to obey the court's directive not to exclusively photograph and record Mr. Kober to the exclusion of all aisles, jeopardizing his ability to undergo a fair trial. Blah, 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 blah. Just another thing to slow everything down. You know, why all these restrictions? Why all these restrictions? If he didn't do it, why all these restrictions? All right, we get the motion to dismiss here. Comes now, state of Idaho, and through the Latah County prosecuting attorney, and respectfully moves the court of an order extending the time for the state to respond to the defendant's August 23rd, 2023 motion to dismiss indictment on the grounds of biased grand jury, inadmissible evidence, lack of insufficient evidence, and prosecutorial misconduct in withholding exculpatory evidence. The defendant, it's funny, you know, she talks about withholding evidence where even when they were in the motion talking about the evidence, she even said she backpedaled. Ann Taylor backpedaled and said, I am not saying that Bill Thompson, she said it in court, it's on the record. I am not saying that the state is holding anything. She backpedaled when Judge basically painted her in the courtroom with a paintbrush, and she backpedaled after a hard talk through all these motions. Then when she was in front of the judge, she backed up and she said, well, I'm not saying that they're withholding anything. You know, I'm not doing that. And I think that was what, three or four hearings just before that. So again, this is all things just to keep slowing this process down, because they know they don't have anything, in my opinion. All right, let's go here. It says the defense motion was filed in the afternoon of August 23rd, 2023, and it was accompanied by a memo to support comprised of approximately 109 pages, 49 pages, which made up the defendant's arguments, and the balance made of the various exhibits, which include affidavits and materials. Along other things, the defendant's motion asserts detailed, factual, and evidentiary issues that require not only review and submission of the entire grand jury transcript so that the court is able to access the defendant's claims in context, as well as it appears to be complex scientific representations and disputes. In the light of the above, the state will unable to properly research and respond to the defendant's motion by August 30th, nor prepare for a substantial hearing on September 1st. The state, therefore, respectively prays that the court extends the time for responding to the defendant August 23rd, 2023 motion to Wednesday, September 14, 2023, with any reply from the defense due to September 20th, 2022. The state further prays that the court vacate the hearing currently scheduled for Friday, September 1st, 2023, and reset the same for the September 2022, September 22nd, 2023. The state concurs with the defense request that the grand jury motions be heard at the same time. Consequently, the state prays that the hearing on the defendant's prior motion to dismiss indictment based on burden of proof also to be continued and set concurrently with the hearing on the defendant's August 23rd, 2023 motion. The state has asked defense counsel whether they agreeable to this request and have indicated their agreements. See Ms. Taylor's signature below. The state further responds. So again, my apologies. This was filed by Thompson, and you see Ann Taylor has no objection to this. It's basically setting meetings, and it's good. It's more things just to slow the process down. All right, let's get into Lawyer You Know. see what he had to say about some of these legal documents that had just recently come up, and get a lawyer's perspective, because I am not a damn lawyer. We just hang out and try to do the best interpretation and give our opinions as to what's going on in this case. Let's play through this. Oh, I need volume.
I'm going to be helping out with that. And in order to do that, you have to like take test, background check, fingerprint, all that stuff. Tons of case stuff going on. We resolved a couple good ones this week, which was always interesting. We've got one continued that was supposed to go to trial. It's just been a really busy week and culminating with a busy Friday, but I'm pumped to be hanging. I mean, they're not going to still try to strike the death penalty. Okay. So that's about every possible appellate issue surrounding delay and speedy trial in the case. Now, not to mean they're not going to still try to strike the death penalty. Okay. So that's important to keep that in mind because we know that. We're also going to look at this motion to dismiss and the sealed nature of it and what's sealed and what could potentially be in there. And then we're also going to just very quickly talk about the defense's response or reply to the state's objection to their motion to dismiss. And this is, again, taking us back to the legal standard and burden of proof beyond reasonable doubt versus probable cause in the grand jury indictment process. So that's what's on the agenda for today. If you're here for that and you like that, then like this video for me. All right, let's just keep liking videos, spreading good vibes only. What an easy way to spread good vibes. Subscribe to the page if you haven't already. We're growing towards 300K. Every time we hit a milestone, it blows my mind because I never, ever expected this. I never expected to help so many different clients that found us through YouTube, which is wild as well to think in today's day and age.
Great.
You can find your lawyer and find clients that, you know, you have life-changing experiences with literally, and be there during some of the toughest times for people and try to help work their way out of them and get them justice and get them back on their feet and get them made as whole as they possibly could be. It's wild. And it's an awesome thing to be reminded of as we come and hang on this stream together. I am really fortunate and just pumped to be able to do that and have that be part of my life and have this be part of my life and you all be part of my life. All right, let's get into the defense's reply here first. And I'm going to kind of go through this one quick as to not bore you. We read that entire thing together. We know what the defense's argument is. I just want to kind of highlight their two main points here of this reply to the state's objection. And again, this has to do with the probable cause versus beyond reasonable doubt. This one to me has been a pretty simple legal standard that I think the judge is going to only take a few seconds to figure out why the defense is just wrong about this. The probable cause standard in the grand jury indictment is something that's been in there forever. I don't expect that to change. And I don't expect the judge to really think twice about it. So the defense, after the state objected and said,
I kind of see what's going on about the FBI going to talk to Gabriela Vargas, and I'm kind of reading the chat here. So let me just get this out. So what happened was there was some conversation and some information that came out on social media that Gabriela Vargas was talking about her testifying in court. Apparently that's what I heard, and also about the processes that the either police or FBI use to process IGG information, and that she recanted some things through her posting that she had said in court. So Bill Thompson had heard about that and had asked someone to go over and investigate, i.e. the FBI, because the FBI is the lead investigators in this case because they've taken over the case. And Taylor became aware of it. She spoke up the other day in court, put it on the record. Bill Thompson got right up and reacted right to it. They said it in front of the judge. It was put on the record. And after it was said, you know what Judge Judd said? We'll sort through these things. It didn't really seem as a big major concern at this point. I'm sure down the road, there'll probably be a hearing about it, but it's on the record. They know about it. And they wanted to ask her, what were you talking about? What did you recant? So I think all viable questions, I think all viable avenues to investigate. I don't think there was any witness intimidation like everybody's going to say, because I'm going to tell you right now, this fucking conspiracy theory with that, it's going to run for months now, because Idaho content is going to dry up for a while now, and everybody's scrambling and scraping now. What is the next thing that we can jump on and try to keep this going for a year? I already saw the streams that day popping up. I saw Twitter was lighting up. Conspiracies going everywhere. But if you're trying to hide anything, why would you stand up in court and testify in front of the cameras, millions of people, and put it on the record? That's just my opinion. I don't know. Anyway,
That's basically how we've always done it. This is what the Supreme Court says. This is what the statute says. The defense basically has two major arguments. Number one,
exactly, Mary.
there is no Idaho Supreme Court authority binding on this court as to the standard of proof for a grand jury. And again, they basically argue semantics. Then section 2, I said
Absolutely.
2 arguments. I think there's 4. There's only 2 that I think are even somewhat legitimate. Number 2, section 191107 sets the standard of proof for grand juries at beyond a reasonable doubt. This is literally the same exact argument they made before. If the judge wants to see it this way, this is how they would win. I find it very, very unlikely. Argument number 3. These 2 rules conflict, and the rule does not, the code and the rule conflict, and the rule does not control because it is a substantive right. Again, ad nauseum, we read through this and the other motion. I don't think this is going to be controlling, but if it was, sections 2 and 3 is how they actually have a chance to convince the judge, which would overturn and cause such a crazy ripple effect. I can't even let my brain go there. I feel like I'd be in the Spider-Verse. And then lastly, which is another one that I just think is interesting that the defense points this out. Mr. Koberger asserts a theory the law allows and seeks a remedy the court can grant. It's like, you do actually have discretion to do this, judge. Anytime you've got to convince the judge that they do have discretion to do something, it's probably not the strongest argument. And then the last one, I was wrong. There's 5, is just categorically wrong. The state also appeals to its decision appends to its decision 3 district court opinions claiming they are persuasive authority. Certainly all these respectable jurists, meaning judges, may have attempted to tackle these issues, but they did not have the benefit of Mr. Koberger's briefing and research. It's like they didn't get to read all of the great work we did, Judge. And those district court opinions are not persuasive, they say. Well, again, I think that is just wrong. There is binding authority, which the Supreme Court would be, where this court would have to do it. That's why they say the Supreme Court hasn't ruled on this, Judge, because if the Supreme Court did, you have to follow the Supreme Court. That's binding. Persuasive is simply a secondary source, like another judge, that the court may follow, but does not have to follow. And that is exactly by definition what these 3 district court opinions are. They are persuasive. The judge should read them and may follow them, but does not have to. He can disagree with these district court opinions. But the fact that they say they're not even persuasive, I don't even understand. I don't even get it. I don't get legally what they're trying to say. So what are they? So that means they're either binding or they're worthless if they're not even persuasive. So again, I don't think there's a ton of value in that document, but some of you asked me questions about it, so I wanted to read through it with you and just kind of give you the over-the-top view. We already read that entire document together, and those of you who are champions of this channel stuck through the entire thing with me. All right, next, let's look at the speedy trial waiver felony. And the language is what I want to focus on. We know he signed it. We heard him verbally say he wants to waive the speedy trial. Nobody's forcing him to. Absolutely, he wants to do this, okay? So let's read just in case. Now, again, having it filmed and recorded is actually a benefit if there are appellate issues because we know exactly what he said. Now, you can always get it transcribed and get the court reporter. But the way he looked, and if he said, oh, well, that's what the court report, I mean, I can't tell you how many people have said, that something that was written down did not happen the way it sounds. You know, you can get wrong context in text messages or emails. That can happen. And the same thing has been argued in court documents, in transcripts. No, that's not how I said it. That's not what I meant. So video can actually add context to all of these documents and everything that happens throughout the case. All right, so let's read through this in black and white. Brian Koberger signed it and Taylor signed it. The defendant acknowledges that the defendant has a right to have this case brought to a trial within 6 months of defendant's arraignment in district court on an indictment or within 6 months of the filing of the information. And this is just a generic form that they have them sign once they go through the colloquy. Further, the defendant acknowledges consulting with defendant's attorney regarding the right to a speedy trial pursuant to the Sixth Amendment of the United States Constitution, Article 1, Section 13 of the Idaho Constitution, and Idaho Code, Section 193501. Now, what's just interesting and behind the curtain is as we read through these things and you think, gosh, they list a lot of things out. Well, for the most part, if you have boilerplate language that lists out a bunch of different things, it's because in the past, lawyers have made arguments that certain things disqualified this waiver or made it faulty or incomplete or unknowing or unintelligent. What do I mean by that? The defendant acknowledges, this is still paragraph 1. I'm rereading the second half. The defendant acknowledges consulting with defendant's attorney because in the past, there have been arguments made that, well, the defendant didn't even get to consult with his attorney before doing this. And there were times when the attorney for defendant's signature wasn't on this document. Then, regarding what did he get to consult with his attorney with? His right to a speedy trial for the Sixth Amendment of the United States Constitution. Okay. But wait, Judge, and I'm not saying these were all successful arguments, just arguments that lawyers make. But Judge, nobody advised him of his right under the Idaho Constitution. Okay, let's add that in there too. He's been advised Article 1, Section 13 of the Idaho Constitution. But Judge, nobody advised him of his right of the Idaho Code, where in the actual rules, it states a speedy trial. Okay, let's add that in there too. They have discussed all of these parts and he knows what he is waiving. And it's not just the United States Constitution, but also the Idaho Constitution and Idaho codes. And now with that context, let's read paragraph 2. It's just interesting to think about that. It's like we want to make sure all of our I's are dotted and T's are crossed in everything that we do. Based upon careful consideration and consultation with the attorney, the defendant waives the defendant's right to speedy trial. The defendant fully understands the advantages and disadvantages of waiving the right to a speedy trial and believes that it would be in defendant's best interest to give up this right. So another important factor, there are benefits, there are advantages and disadvantages to demanding speedy trial and waiving. So in order to waive in writing, he's saying he believes the advantages of waiving speedy trial outweigh the disadvantages. And the disadvantage of demanding speedy trial is outweighing the advantages. All important factors here as to why he's making that decision and not being coerced or forced or tricked into making this decision. The defendant further understands that once the right to a speedy trial is waived, the court may set this case for trial more than 6 months from the time in which the defendant was arraigned in district court on an indictment or from the filing of the information. So in court, the judge did a really good job of saying, we may have to continue this case in the future. That may be necessary. And if we do, you need to realize that you're waiving your right to say, no, you can't do that because I'm demanding a speedy trial right now. And they put it here in writing, a little more vague, but that this trial does not have to go within 6 months. And he needs to understand that, and hopefully does understand that. All right, let's answer a few questions here before we get to the motion to dismiss. First, we've got Twitchy Witchy True Crime, Wafa Jones, Miranda Campbell as new members here. M. Lebrecht, Peter, did you get my email from 8-4? I am not sure if I did. Need a little more context than that, probably. 40 Daughtry. If BK hadn't waived speedy trial, could the prosecution have dropped charges and refiled them to reset them 6 months, to reset the 6 month period? Is that a loophole? No. This is a great question. And again, probably because it happened is why the rule specifically states the prosecution cannot circumvent the speedy trial rule by dismissing charges and then refiling those same charges to reset the clock. Great question, and it's been thought of before. Channeling the Heart, Barbara Joyce, honorary PhD for BK. A lot of people are saying they think he's driving a lot of this, not his lawyers. Be really interesting if a criminal defendant with a public defender could convince them to do this kind of research and go way back into history, writing these 70-page documents, trying to convince the court that we've been applying the wrong standard to grand juries for forever. Peter, do you think he should have waited a bit longer to waive speedy trial? I don't know if I would say he should have. I would say I probably would have. I would have at least tried to wait until I forced the state to give me all the discovery that they already have because the deadline was coming up. But I don't think there was anything wrong with waiving it when he did if they knew that that was going to be the inevitable end of this as well. Steph C. Would the Idaho Supreme Court ever take up clearing up or tightening up the grand jury beyond a reasonable doubt assertion? Would it require a case or can they take it up on their own? So it would probably require a case. The Idaho Supreme Court cannot write law. The Idaho legislature could look at this and say, we need to make this clear. Let's make a rule or statute that specifically states it out and disclaims this whole argument of beyond a reasonable doubt. But I think it's possible. Welcome, Jennifer. And thank you, Annie K and LC for these super chats. All right. Let's get into this motion to dismiss, which is rather interesting. All right. Motion to dismiss. Indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct in withholding exculpatory evidence. And let's dig in here. Comes now, Brian C. Koberger, through his attorneys of record, and files a motion to dismiss indictment on grounds of a biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct by withholding exculpatory evidence. The motion is based on the state's various violations during the grand jury pursuant to Idaho code, all of these different codes. Mr. Koberger raises 24 issues, which are set forth in full in the memorandum in support of the motion to dismiss the indictment and its attachments. So let's take a look here at the next document, which is the defendant's motion to file memorandum in support of the motion to dismiss indictment under seal. So all the documents supporting their 24 issues they want to file under seal. We don't really find out why. They just moved the court for an order to file the memorandum under seal. They didn't say to protect anybody's name, to protect the grand jurors, the potential witnesses. Maybe that's just supposed to be understood because they cite the rule here. But they want to file the entire memorandum in support of this motion to dismiss under seal. Now, they didn't do that when it came to the last motion to dismiss based on this, argument about probable cause versus beyond a reasonable doubt. And then almost immediately, as has happened throughout the entirety of this case, Judge signs an order to file the memorandum in support of the motion to dismiss indictment under seal. This court, having before it the defendant's motion to file a memorandum in support of motion to dismiss under seal and good cause appearing, now therefore orders that the memorandum in support of the motion to dismiss the indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct in withholding exculpatory evidence shall be filed under seal. We don't know why. We don't know what the justification is. We don't know who they're trying to protect as far as identity or things like that, but we can assume it is something like that. So now that we know it's under seal, I'm going to answer a few questions before we go back to this document, which was the motion to dismiss, and we discuss what possible factors would fit into these categories and what it usually means when you have 24 different issues that you're filing a motion to dismiss on. Susan Steele, thank you for the super sticker. Natasha, what would it take for the state to change the amount of time for a speedy trial? Is that likely to ever happen? It's very uniform and similar from state to state. It's not exactly the same. So I don't know. I really don't know the answer to this. I think enough lawyers around the world would have to be convinced and talk to, I mean, you guys have, a lot of states have elected legislators that write these laws. We have bar associations like the Florida Bar that writes laws and edits laws. So it is possible if we found that it was necessary, but I really don't think that there's a lot of a groundswell or push for that. Like I haven't heard a lot of talk about that in the criminal defense circles or in the criminal law circles. My dad is, been on every board and president of every organization, and there really hasn't been a lot of push for that. But next time he's on, he's going to Alaska on vacation, him and my mom. So they're going to have a great time. But when he comes back and when he comes on again, let's ask him what he thinks about this and if he thinks it'll ever change. Does pickleball require a real pickle? No, it does not. Shockingly enough. I will tell you, even if you're not into pickleball, but you like making fun of it, the Instagram reels and memes making fun of pickleball are top notch. Top notch. LR, will we ever see what those documents are once this goes to a hearing, or will it always stay sealed? Well, I'd be able to answer that better, LR, if I knew what the reason was for sealing it, right? If they say something about timing or something about poisoning the jury pool or something about witness identity or grand juror identity, some of that stuff's never going to get unsealed, but others could get unsealed maybe after the trial starts even, at different periods, depending on who it is. Maybe when their witness list is revealed and these witness names become public, then it can get unsealed, but it's hard to tell based on the limited information we have. M. Liebrick, it's about an RN license suspension. So that's not ringing a bell. I don't handle that specifically. I've never done any license suspension work. I could try to find somebody maybe that does it, but I off the top of my head, I don't know a ton of lawyers that handle nursing license suspension or any kind of, admin law like that. Twitchy Witchy, question for those of you saying you'd never waive speedy trial if innocent because you wouldn't want to sit in jail forever. Would you chance death penalty or life in prison if your lawyer wasn't ready? So I have not completely seen the chat, but that is categorically false. I would say, a much higher percentage of innocent people or people where the trials end up getting a not guilty verdict, a much higher percentage of them waive speedy trial than don't waive speedy trial. I will also tell you, a vast majority of private lawyers waive speedy trial almost immediately. And a lot of those cases end up in not guilty verdicts. I don't want to say all of those people are innocent. We know how that works. Not guilty includes innocent and not proven cases. But that is not a factor in guilt or innocence, whether or not you waive speedy trial. It really is not. Almost the opposite could be true, right? If you know you did it, but you don't think they can prove it, if you push them and you hurry them up to trial, then you demand speedy trial. But I wouldn't say that either. I wouldn't say that if you demand speedy trial, that means you're guilty. That means you did it. I just know that in the field, when they discuss strategy, that is a strategy that is discussed. D-Trug, 24 issues. It's either the worst indictment ever or the defense is pushing every little possible problem. So let's take that question first. 24 different issues. We talk about this mostly when we discuss appeals and how you want to focus on your best issues and highlight the major issues to the court. Because if you say you have all these issues, is the court just going to say you're nitpicking, kind of like you said here? And is just going to kind of disregard all of them because 20 of the 24 are weak? And is that going to make his eyes glaze over and he's just going to go over the important issues? He shouldn't, obviously, and I don't think he would, but you run that risk. That's why usually you pick the best issues, and usually like when you have a bunch of issues, that usually means it's more watered down rather than truly horrible. Although I think your question is perfect. It is one or the other. And maybe it really is just the worst grand jury proceedings of all time. That's possible. Debbie W. Personally, I think part of why it's sealed is to keep the evidence from getting out before trial. Well, could be true. At least a percentage of it is in the probable cause affidavit. Rebecca, there are union groups in your state that can help you with RN license suspension. There you go. It's an answer that I couldn't even give because I honestly don't know. I know Rebecca, I believe, is also a nurse. But yeah, that's why I'm probably not going to be the one to help you with that, but I will think, and if I can think of somebody, I will let you know. Allison, off topic, any chance at a second fantasy football league? Sure. I can't put it together and run it. I am like maxed out on the ones that I actually commish and run, and I don't want to mess anything up or miss something. But if one of you guys want to run it and you want to send me an invite, send me an invite. Maybe John or Jeff or myself or Pete or somebody else can run the team or draft the team with me to give it a little different spin than the league that we're doing already. So yeah, I would be in if one of you guys starts one for sure. Okay, so let's discuss here what could fit into these different categories. So first is a biased grand jury. Now, there are two ways. There are explicit and implicit biases. And implicit bias has had much more of a push these days, especially in jurors and presentations and legal seminars. We've talked about implicit bias and how you can try to pull that out and try to figure out which jurors may have it and be bad for your client or good for your client or whatever it may be. So when we talk about this, filing a motion that says the jury was biased, that can either mean it was so obvious based on their job, based on their answers, based on their background, based on what they said about their family members, that they were biased. But to try to use implicit bias in this type of a situation, I think will be very, very difficult, because then usually you may have to say some things that you might not be 100% sure of to say this person has an implicit bias. Because by definition, implicit bias is usually not something they're explicitly saying or letting it on to, right? So I would think that they have at least something in the grand jury transcript that a juror said that would make them at least arguably biased. Now, this would be more akin to somebody that should have been struck for cause. It has to be very obvious that they should not have been put on this jury, and they were. So I think that one's going to be tough to prove. Number two, inadmissible evidence. Now, the rules of evidence are different in a grand jury, and the judge usually can step in if there really is something inadmissible or horrible going on. And inadmissible evidence is different than presenting evidence in an inadmissible way. So they were saying they put evidence in that should not have come in. Now, I believe, and this is just a pure guess because we don't know what the answer is, I believe they could be referencing the DNA here. They could be saying the state has not provided enough to prove the reliability of the DNA, yet they put it before this jury. And if you remember back to the probable cause affidavit, they said we have probable cause even without the DNA. But if they're just using something that we know they're fighting about and arguing about and trying to get to the bottom of, and they think that they may have gone around or circumvented some of the rules or used things they shouldn't have used in the process of processing the DNA, that could be inadmissible evidence. Now, of course, inadmissible evidence could just be them making up stories of testimony that didn't happen or some of these other crazy theories, of course. But from my perspective, that's the first thing that popped into my mind, is something like that they've argued about. Now, we don't know about a lot of evidence in this case. So they could be arguing about something we really just don't even know about yet because of the sealed documents and a lot of the things that have not been made public yet, and the gag order and things like that. All right. Next, lack of sufficient evidence. So this could be a re-argument of the burdens of proof. Like they had sufficient evidence to clear the probable cause burden, but not sufficient evidence to clear the beyond a reasonable doubt burden. That would be inefficient, or what was it? Insufficient? Lack of sufficient evidence. That's what that would be, is not enough evidence. So inadmissible evidence is evidence that should have never come in regardless. But lack of sufficient evidence means even all the evidence that came in, it was not enough. And that usually attaches to a burden of proof. And then prosecutorial misconduct by withholding exculpatory evidence. And I'm not even going to try to guess what this is because I don't know what it is. But what I will say is this defense team has not been shy about putting the words exculpatory evidence in so many public documents. They know the actual memorandum of law or memorandum of facts in this case is going to be sealed. But they know what also is not going to be sealed, which is this motion that has the titles of some of their issues. And it doesn't list 24 things. It lists kind of bigger buckets that multiple issues and basis for this motion to dismiss is going to be public. So they say that the state did not present exculpatory evidence. There's multiple ways this can be a problem. Hiding something, misstating something purposely, disregarding something. But the way that they do it could have something to do with whether or not it was prosecutorial misconduct. But to me, I think the defense wanted to put the words exculpatory evidence in another motion for the public to see, because I've got to be honest, both of these teams, state and defense, have seemed like they want the gag order. They don't want the cameras. But both of them, to me, have also seemingly said stuff and done stuff knowing there are cameras and the public's eye on this case. And just in case you think I'm just doing it to the defense, which I think most of you won't, because I think most of you think I'm defense friendly, the state also did it in the motion hearing when, instead of just having the hearing or filing a written document, Thompson stood up and said, whoa. The only reason the FBI went to Vargas's house was not witness intimidation, was just because she recanted and they wanted to get her statement. And he felt like he needed to explain that in front of the cameras after Ann Taylor said in front of the cameras, the FBI showed up to my witness's house last night. We can't be having that. So I think both sides are doing certain things knowing that they are in front of the cameras. Let's get to a couple more questions. Yeah, 5,000 people here again. You guys are awesome, showing up and showing out for the lives. Hit that like button if you haven't already, and subscribe. I love to see the community grow. Gingy Probs joined late. Hey, all, my question. Do we know next appearance for this and or Treviso? Can't stop thinking about HIPAA, LOL. Y'all have a great weekend. I don't know the answer for Treviso. I believe the next time they're meeting on the Koberger case is going to be September 1st. And I believe that's when they're going to hear this motion to dismiss and the prior motion to dismiss, as well as motions for the cameras and things in the courtroom. It's either September 1st or September 8th. They had those two dates. I believe it's September 1st. So that's going to be coming up very soon. I don't know about Treviso. Jeep Innis. Speedy trial should be held against the prosecution only. Defendant shouldn't have to rush. The prosecution is more ready from the jump. You know, that's an interesting thought. What if the prosecution had 6 months to get everything they were planning on using to the defense? All of their evidence, all of their witnesses, all of their experts, they had to give it to the defense. And then the defense has 6 months to prepare their case. And then we can give each side another month for rebuttal and things as they prep for trial. And then that turns the speedy trial rule into basically a year. So all these cases get held within a year. But you're right. The prosecution already had as much time as they want to prepare this case. The defense starts behind the 8 ball. That's why I say a lot of times, it's not that I like every criminal defendant. I just say the process is set up to make the entire system much more difficult on criminal defendants than it does on prosecutors. Coming from somebody who has tried cases on both sides of the aisle. My dad as well, JD as well. Lots of lawyers in my firm have tried cases and represented the people of the state and represented criminal defendants. Deb, your invite link is in the chat. Okay. John, can you save that link? Hopefully you can find it. If not, post it again, somebody. Tracy, thank you for the super chat. Rebecca, defense is throwing everything at the wall to see what sticks. That being said, innocent until proven guilty. Nobody should be disparaged against here. I agree. And I think that the way we should look at this, in my opinion, I don't like telling people how to think, but taking your lawyer's advice and doing something, a legal procedure that is afforded to you, like waiving speedy trial, or even going to trial. A lot of people think only guilty people go to trial. It's like, well, how else are you going to prove you didn't do it unless you go to trial? Or only innocent people go to trial. It's like, well, that's not true, because lots of cases, the worst of the worst cases go to trial because your offer is life in prison or life in prison, or the death penalty or the death penalty. We're not making any deals. So legal procedures and decisions, especially with the advice of counsel, should not be held to prove somebody is more or less guilty or innocent. The facts of the case that come out at trial really should be all that proves whether or not somebody did the crime they're charged with. Gingy Probs, the state is in its exculpatory evidence era. How do you feel Ann Taylor is doing? I think she's doing a good job. You know what's interesting? So, and I don't, oh man, I already X'd out of it. So if you look at some of the, and I just noticed this when I was reading this today, but if you look at the history on beyond a reasonable doubt versus probable cause, now, I'm sure Ann Taylor has something to do with it. I'm sure she's approved it, whatever it may be. But a lot of those are written by Jay Logsdon. And the stuff I just been like, eh. So a lot of that hasn't even been Ann Taylor, but I think she's done a good job. I don't think she's one of these lawyers that's trying to play like, waving her hands, slamming things on the table, trying to really play it up for the cameras. I think there are some things strategically that she does, knowing the cameras are there and the public eye is on it. Okay, so yeah, but I do think she's doing a good job overall. I would absolutely be giving her a high grade so far. We'll see how the trial goes. So I did want to.
Your hat.
I did want to mention something else. So we have a brand new short posting today. That's a fun one. It is a 1 minute day in the life of working at a firm with my dad. And it's pretty funny. And you get to meet some more of my family members in it. If you want to check it out, as soon as it's posted on our short page, we're supposed to already have the link, but I guess it is not posted yet. As soon as, all
right, let's see here.
As soon as that is uploaded, we will share the link here. Daria said, it sounds like you said chorizo, not Treviso. Very cute. It's Treviso? Chorizo? Not sure. You guys know how I mess that stuff up all the time. Tara, what is the precedent on handling a witness problem that just occurred?
Oh, my back.
Handling a witness problem that just occurred. I'm not positive what you mean, but if you mean sending the FBI out to their house that same night, usually that is not the proper way to handle an issue with a witness. The most natural way would be to call her back into court and say, we heard your recanting part. Is that true? Is that false? Or even bring her into the state attorney's office, whatever it may be. But usually sending FBI agents is unusual. It is not the normal way to handle it. But also nothing illegal about it. You can send investigators or FBI agents to follow up with a witness statement and take their statement. There's nothing wrong with it. Just seems a little weird.
He just said it. It's okay. You can do that.
Bodie, do you pay your non-lawyer family? All of the ones that are in this video, the answer is yes, because they work at the office. We have 3 or 4 people in my family or extended family that work in the office. Question. Is it odd for Ann Taylor to bring up the second phase already? Is that normal? Couldn't that give the impression he's guilty? So I get why people would think that, but the reason she's bringing it up, and again, we all got to see this together. So even if you're not a lawyer, even if you haven't experienced this, the Nicholas Cruz Parkland trial, the entirety of that trial was just phase 2. So it can be a trial in itself. It is a second trial. It is a completely second job. It's like having two cases, not one, when you have that second phase. So saying she's prepping for this trial, for phase one, does that mean that she knows it's going to go to trial? Or does that mean she knows he's guilty or not guilty? No. She just knows that that is something she has to prepare for. The case could resolve. He could plead. Just like it might not ever get to a second phase. It doesn't mean she's not going to be prepared for it when they start trial day one, because as Mr. Thompson said, they're going straight into the second phase. Mitchell, do you think they're hiding evidence? I would say no. I do not think they're hiding evidence. I do think they're holding everybody to the rules, and if they don't think something is discoverable, then they're not going to turn it over. I wouldn't consider that hiding evidence. Do I think sometimes they go overboard with that? Yes, but if they're ordered to turn it over, I think that they will. Capelli, welcome to the membership crew.
I'm not going to play that. I have something else.
Blessed Mom from Texas, my email, lawyeryouknow@gmail.com. Send the invite there. And if you're talking about for the fantasy league, I don't know, car accident investigation in full. Number 2.
All right, let's watch and see what Sleuthy had to say.
That we've already gotten a vibe here together in these videos. Sleuthy Goosey has a question here. Do you think the FBI is not providing them things they need to turn over? They've basically said as much. Will there be any repercussions on the state for not complying when the FBI won't give it to them? So, loaded question here. Number 1, yes, I think that the FBI is not providing certain things. I don't know. They need to turn over, arguably. I will say that that is arguably discoverable. Yes, and this happens all the time, especially in federal trials where the FBI is handling the investigation in full. Number 2, what will the repercussions be? We have gotten a case literally thrown out when we proved the FBI did this and destroyed a piece of evidence after we won an appeal. And during a trial, the court, it was a federal judge though, which they sometimes act a little different. They're appointed for life, threw the case out. That was the repercussion. Now, there's no real sanction or repercussion for the state attorney if they asked for it and weren't given it. If the court found that they were involved, like, hey, don't give me this, or I'm not even going to ask you for this, or, some text message or email, then absolutely they could be sanctioned. They could be disbarred potentially if they're doing things like this in a criminal case. I don't know that we have that in this case, but I definitely think the FBI has some stuff they haven't turned over. And I think the FBI disregards court orders from time to time. Not always. There's some really good FBI agents, and a lot of times they turn over all the evidence and everything they have in the case, but from time to time, and we've had experience with it, the FBI does do things like that. And they are above the law, so they feel, law enforcement officers generally sometimes feel like they're above the law. State attorneys, they're criminal defense attorneys, right? Prosecutors, we saw Murdoch, obviously thought he was above the law. So there are people in the legal field that absolutely think they're above the law. If I were guilty of a crime, I'd hire JL. He's slimy. Rebecca, can't wait for fantasy. Go Cowboys. Have a wonderful weekend, everybody. Thanks for all you do, Peter. Best chat ever. Hit that like button. I will second that this is, in fact, the best chat ever. And we will probably, Norja said, I haven't missed a single one of your videos, just so you know. That is awesome. That is awesome. Okay, so with that.
All right, I don't think there's much more here. We're going to bounce out of that one. There's a video that I wanted to play from Court TV the other day that we never even made it through. And it had a lot of commentary. And it was during the hearing itself, which is atrocious. The audio from that hearing is atrocious. Yeah, Victorina, I appreciate you. 5 months subscribed. How many? I don't know how many months a moderator. Been a while, maybe 2 or 3 months. Victorine has been here from the beginning when we had those streams in March when there'd be like 4 people in the chat. But those are all the good times. Building the channel. This is the hearing. You know what? I'm not going to play through this. We've already played through it. I want to hear the perspective, though, on the flip side, which was here. Let's go to here, and we'll play out maybe another 10 minutes or so of this video. Let's back up a little bit. So we heard the hearing.
Expanding the panel. Okay, because I was thinking that I need a lot more potential jurors to show up.
All right.
All right, we do want to bring in one of our guests tonight, criminal defense attorney Elizabeth Baker. Hi there, Elizabeth. Okay, so we have been watching this hearing where Bryan Kohberger waived his right to a speedy trial. Now, it seems like we don't know when this trial could get underway. What are your thoughts?
Well, I'm shocked they didn't waive prior to this time. That would be the normal course in a case of this magnitude, especially a death penalty case. It is something that, I mean, what I believe is that the defense probably hadn't waived the speedy trial issue because they were hoping to have their client testify at the preliminary hearing and or at least test the state's evidence out.
Using her members chat. She's been a member for 4 months. Like and subscribe. It's free and a great way to support. I appreciate you. Let me go back up here and I got to recognize this too. Lakota, thank you so much. Member for a month. Haven't heard if the plans are going forward now with demolishing the house with no trial date in sight. I suppose they will move forward. Very sad. I think so too. Unfortunately. Sorry, I'm yawning. I think unfortunately it's probably going to happen. I appreciate you all, though, for being members of the group and supporting the channel. We are growing rapidly and trying to get to that 10,000 subscriber mark. Right now, it stands at 8863 as I'm looking at the number right now. Let me do some quick math here. How far away are we? We need to find 1,137 more people to get us there. So make your fake accounts 1,137 fake accounts. We'll get there overnight. All right, let's play through this. I wanted to hear this perspective here, and then we'll get this closed out here for the evening.
The preliminary hearing. It sounds like there may be some motions about the preliminary hearing or the indictment process that the defense is going to be filing. But this is completely within the norm for a case of this magnitude. There is what would be really out of the norm was to have a case like this go to trial within a year. I mean, these homicides were last November, and that would sort of be asking for this trial to be tried multiple times because of constitutional errors.
Yeah, his attorney even argued and said that this ensures that he will have effective representation, which of course is extremely important. Elizabeth, thank you. I also want to bring in Court TV legal correspondent Chanley Painter. She has been covering the Idaho student murders case from the very beginning. So Chanley, I want to bring you in to get your take. What do you make of Bryan Kohberger's decision to waive his right to a speedy trial?
Great to be with you again, Kelly. I think it was to be expected, given the hearing that we were present at last Friday and the really intricate scheduling conference and order that was issued saying that certain deadlines for certain dates to meet that October 2nd trial date that was still set, and it is a death penalty case. And at that point, the prosecution, raised the red flag, saying it seems pretty unrealistic. But at that time, the defense didn't waive the right. They instead asked for this status conference, possibly to sit down and discuss it further with their client. We know in the state of Idaho, Kelly, that a defendant has to be present in person at a hearing in order to waive a speedy trial, because there is that colloquy back and forth with the judge that happened today. So it was to be expected. I've been in communication with the victim, Kaylee Gonsalvez's family, over the last several days, and today just now communicating with her father and how they were fearing this because they want this to happen as soon as possible, some sort of closure and justice, and they're afraid now that since he's waived the speedy trial right, that it may put this years from now before they actually receive full justice for Kaylee and her friends, the other victims in this case. So we do still know that as far as right now, there's still a hearing for next Friday to take up the defense motion to dismiss. They're trying to attack the very indictment against him. They actually asked for a stay several weeks ago so they could further investigate the grand jury process. That was granted and fulfilled. So we can expect them to still be challenging every step of the way what the prosecution does, Kelly.
Yeah, Chandler, and you did mention Casey Gonzalez's family, and I know they've been so active on Facebook. You've had encounters with them too, and they really were saying that they really feared this because, as you mentioned, now this could go on for years. And when you talk about any kind of closure, not that there ever could be any closure for family in this case, but before it was supposed to be set for October. Now it could be years. Just heartbreaking news for the family. They said that this was something they feared, as you mentioned. Anything more from them?
Absolutely.
Yeah,
Yeah,
me
absolutely,
too.
Kelly. You know, in communicating with them, and like you said, they do have a very active Facebook page, the Gonsalves family Facebook page, where they post.
So Dr. Bob says maybe we should get original 12 hats, been a ride. Original 12 hats, been a ride. What's that? Explain, Dr. Bob. Get original 12 hats, been a ride. What's that? Am I missing something? It's probably something funny, but I'm not getting it. What's 12 hats? Help me out. Help me out.
People that send them encouraging messages and gifts from all over the world, and they post photos and updates about, Kaylee's new niece that's named after Maddie and Kaylee. Her name's Maddie Kay. They post photos of her, of the dog Murphy that was at the scene when the murders happened as well. There's updates on him, the dog, and they posted earlier today asking for prayers because this was such a fear, especially
I understand
Kaylee's mother, Christy, is very in distress, very in distress at this decision. And so what I know of them, and I've seen them in person, met them in person, obviously, they are each other's support system. And so they have each other through this time, and that seems to be where they're going. And there wasn't a trial date set yet, Kelly, so that's another sign that we may, it may be a week or two or more before we learn an actual trial date for them. And we know with death penalty cases, it's a lot more complicated and a lot more filings to come that we'll be covering as this moves forward.
Sure. And Chandler, we did hear the judge talk about jurors and how he's already getting excuses from potential jurors in this case. I just think it's really going to be tough to find some jurors who don't know anything about this case. I would think the excuses are going to keep on coming.
Absolutely, Kelly. That's a great point that you bring up. I've been to Moscow, Idaho, many times. I've lost count of how many times I've been there in that community. It's a wonderful community. Latah County is a beautiful place to be. It's a rural, small part of North Idaho, and everywhere you go, people know about this case.
Thank you so much for the super duper duper chat. Thank you so much for the super duper chat.
Great cash, homie.
She says, is it me or just mad disrespect that Mr. Koberger didn't bother to wear a jacket in court? What is this world coming to? Yeah, I noticed that too. I noticed the coat wasn't worn. Maybe it was warm that day too. I don't know. It was a little weird. Good catch. And thank you so much for the $4.99er. The $4.99er helps. Thank you.
It's of course they know about it, and it's kind of like the elephant in the room. A lot of them don't even want to talk about it or mention it. They want to move on from it. And it's a university town, so the town of Moscow is maybe around 11,000 in population, but when students are there, it's like 20,000. It's like doubles in population when school's in session. So it's very much a college town, not far from Pullman, Washington, another college town as well. So I can see where the judge is concerned, and they're going to have to make sure that all the precautions are in place to impanel a fair and impartial juror. I know that he mentioned he was going to summon 1,000 jurors the week before, the October 2nd trial date to try to narrow it down to those prospective jurors, Kelly. So that will probably be heavily litigated. Will we have a change of venue motion too from the defense? Because again, it's such a rural community there where so many people are familiar with this case.
And Chandler, I'm glad you bring that up. So thank you for talking about that and your insight. I want to ask our criminal defense attorney, Elizabeth Baker, who's still with us. What do you think? Do you think we'll see a motion for change of venue in this case?
Sure, I do. It's a very small community. It's going to be difficult to get that many jurors who are neutral and don't have a preformed opinion about the case. I don't necessarily expect that motion would be positive for the defense. I don't necessarily think it would be granted, but I think it would be expected. Absolutely.
Elizabeth, I just also want to ask you about this motion to dismiss hearing that his public defender has talked about. She's fighting this grand jury indictment that led to Kohberger's arraignment. They mentioned that briefly during the hearing today, talking about that as well as other motions that she's going to be bringing forth. She mentioned she's going to have at least 2 more additional motions in addition to that one. What are your thoughts on that and that motion to dismiss?
Terry, I got about 100 of them that I could never get rid of. Oh boy, that was something.
There could be a number of reasons for the motion to dismiss. It could be that the defense believes that hearsay or inadmissible evidence was presented to the grand jury. I'm unclear about the specific basis. We're probably not going to know more until the motion and its detail is filed with the court and becomes public knowledge. I would say there are probably some technical issues. The problem with motions to dismiss grand jury indictments is that very frequently there's no remedy. And it's very difficult for the court to formulate a remedy. What is the remedy? Is it re-indictment? The case surely won't be dismissed on the basis of a motion like this. I mean, who knows what the defense is saying? If they're saying there was misconduct, they're saying there was hearsay, they were saying there's other evidence which is clearly not constitutionally admissible. We'll have to see what the details are about this.
All right, Elizabeth, thank you so much. We appreciate your insight tonight. It's been a pleasure being with you and hearing from Chanley in this case. And Chanley's just been all over the place. She's been in Las Vegas covering the Randolph case, which has been exciting to watch, and also bringing us some insight tonight about the case in Idaho where Brian Kohberger waived his right to a speedy trial. Some breaking news for you there.
That's it. And this is where we're at now. Brian, ever thought of having a Discord group? Well, Discord, I think, it's shut down right now. Let's take a look. Let's hang out for a little bit. Let's just chill. You want to just chill a little bit? Not have to get into all that stuff. Yeah, this is what happened with Discord. Let me show you. Check this out. This was just announced the other day. Discord starts notifying users affected by the March data breach. Starting on Monday, Discord has been reaching out to users affected by the data breach disclosure earlier this year to let them know that personal identification information was exposed in an incident. The breach stemmed from a security breach at a third-party service provider detected on March 29th involving a compromise of an actual account belonging to a customer support agent. The individual was subsequently disclosed on May 12th through emails sent to potentially affected individuals. The attackers gained access to the agent's support ticket queue, their user email addresses, messages they exchanged on Discord support, and support ticket attachments. In response, Discord says it swiftly reacted to the compromise of the support account by promptly deactivating it, learning of the incident. According to the letters sent and affected individuals, only 180 users had their sensitive personal information exposed in the attack. Discord immediately took steps to address the incident, and through the investigation was conducted, the company says in a data breach notices filed at the Office of Maine Attorney General. On June 13, 2023, Discord completed the review of the support tickets involved and determined that one of the more of the support tickets contained personal information on one Maine residence, including their individual's names, driver's license, and state identification number. The Discord privacy team says in letters mailed to impact users. Discord, a highly popular social media instant messaging platform, claims 150 million active monthly users and roughly 19 million active servers. The third party is an unofficial Discord invite service known as Discord.io shut down last week after a massive data breach that exposed information belonging to around 760,000 members. The Discord.io database was put up for sale now. The new breach hacking forums with threat actor sharing 4 user records to prove that the stolen information was authentic. Sensitive data compromised in a breach includes discord.io members, user names, email addresses, billing addresses, limited solid passwords in respect of the Discord IDs. This information is not private and can be obtained by anyone sharing the server with you. Inclusion in the breach does not mean that people might be able to link your Discord account to given email address. Excuse me. Discord.io expanded at the time. So that's why I'm not using Discord. I think right now. You're welcome, Rising. Absolutely. We got a new wrench. Yeah. So that's why I haven't been using the Discord. And that just got too crazy. It was like way too much drama going on in there. There were people that were just specifically starting drama to start drama and were pitting against me to try to take me down for some bullshit reason. And a lot of the stuff that was spewed on there was untrue. And when I confronted them, these particular individuals with facts, their cases started to fold and they wanted to spread more lies about everything. I know what everybody was doing. I know what those people are part of. I know the groups that they hang in, and they probably was sent into my Discord group to ultimately try to take me down, because rising channels are always a threat to other people. And it's just goofy. I'm not in this for competition. I want people to come here and enjoy themselves. I want people to come here for factual, relevant information. I want people to come here for discussion. You may not agree with everything that I say, and I'm not going to agree with everything that you say. But that's why we come here to do this. So, yeah, no more Discords. Let me see. Brian, did I hear correctly that the green shower curtain, red mop-headed lady talked to GGN telling them that they lied on the stand? Can't remember her name. Oh, the individual that was spoken to from the FBI. She said some things. Vargas is her last name. She said some things on the stand and then recanted her testimony in like some Facebook postings. So that's why the FBI went there and spoke with her. A lot of people are trying to say that's intimidation. I don't know. I don't see a problem. Just kind of goofy. So I don't know. I think that's where we're at. Chat's starting to thin out. I think people are taking off. I don't really have much more. We could probably want to update the board, the big board, before I go. Let's update the board before I go. I don't know. I don't know where to go. I think I'm going to keep doing the variety shows. So look out for those. Our true crime headlines across America. I did one this afternoon that was really great. If you missed it, I'd go over and watch it on replay. And I don't know. I think Koberger stuff's going to slow down for a while. I'm sure there's going to be a lot of people that beat it up like a dead horse for a little while. And I don't know. I might have some more stuff on it. I was going to do the all looking back thing. I thought about it today. That's actually the video that I played in the very, very beginning. It was really one of the first news clips that I could find that actually reported on the Idaho murders. And I thought about doing that, but I don't know. All right. I'm going to head out. I'm tired. See what I can come up with for tomorrow night. I'm sure I'll get something getting to go here. Yeah, the variety episodes are fun. I just got to get more people to get into that. And I think they're missing out. They're a little bit shorter. They're easier on replay. I kept it to like 50 minutes. So if you want to buzz right through it, it's right there. And it was fun. Yeah, they're gonna ride this sucker out. Hey, good night. I hope you have a good night. Yeah, they're gonna ride it out. I'm sure there'll be some stuff that I could bring up. But I don't know. I don't know what to do. I think that I'll be honest with you all. I think some of the true crime channels they may suffer for a little while because again, I always said don't build your back off Koberger. That's why I've been expanding out and doing other things. And you're just going to have to get your audience used to that. And that's why I was throwing out some short form content out there as well too. And I brought in the TBG stuff now. I'm going to probably jump on that and start doing some more investigative work on that. As you know, actually, I'll probably whip a stream up about that tomorrow night. There's been a filing, a small claims court filing. It's over on my community page. You can read right through it. So maybe we'll do some attention towards that. Mary says she likes the interrogation videos. Maybe we can start doing some more of that. But I definitely want to, yeah, I ate ice cream today. I definitely want to keep doing those variety, the crime variety shows. And just, it's going to take a little bit. We just got to get them to stick a little bit with the audience, and hopefully they grow and they become a regular thing because I love doing it. So, all right. And I love all of you. You all are great. You all are great. Yeah. So the only thing about OJ is I think a lot of that stuff's copywritten. So if I was to do it, I'm going to get copyright strikes. Oh, by the way, I have to say this. I am very, very happy. I don't know what happened, but I'm extremely happy lately with YouTube because every time I used to go live, they would limit me right away. And then I would have to send that to review and have someone look at my video. And when they limit you, your video doesn't get enough, the right amount of push. I don't know what it is. Maybe someone looked at my account and reviewed it because I had all these things that I had to keep getting unlimited. But I'm now able to just come live and they're not limiting me anymore. Maybe someone went over and said, hey, he's not doing anything that's out of the YouTube policy. So if anybody from YouTube is watching this, I appreciate you looking at my account because it was becoming very frustrating for me every single time that I would go live literally within 30 seconds because my song was triggering the algorithm and it was bouncing it back. That was hurting my channel to not get my streams out there. And it looks like someone that must have looked into my account and they said that the material that I'm doing is perfectly fine. So I've been happy about that. I haven't had to send anything for a manual review, and manual reviews sometimes can take up to 10 days on a video. So basically that video is just sitting there and it's not being pushed as much as it should be. So I don't know. All good things here, all positive things here on the channel. Let's get this damn channel to 10,000 and then we can have a nice big celebration. We'll have a party. Yeah, maybe it is because the channel's growing. Yeah, it's really cool. It's really, really cool. So, all right, I'm gonna head out. And before I leave, actually, this was kind of funny. I dropped this little video, this little short today, if I can find it. Where is it? Check this out. This is great. So Anthony, when I was on JJ's show the other day, he actually basically roasted himself. Check this out. Someone that owes a lot of money, I probably wouldn't be flying all over the country. I'd probably start figuring out how I'm going to pay people back.
Well, that's why you're sitting there behind a YouTube channel and not 5 million in debt.
He completely roasted himself. He completely roasted himself. That's why you're sitting behind a YouTube channel and I'm $5 million in debt. I think that he was trying to do was roast me and it came out wrong. And he totally roasts himself. Let's hear that again. It's great. Someone that owes a lot of money, I probably wouldn't be flying all over the country. I'd probably start figuring out how I'm going to pay people back.
Well, that's why you're sitting there behind a YouTube channel and not 5 million in debt.
All right, let's do one more and then I'm going to hit the outro and get out of here. I love all you for coming here and hanging out and just making this the community that it is. And we need to keep growing this large community. I love it. And if you're watching this, please make sure to, on replay, just go down there and smash hashtag replay. I'm going to do some TPG stuff tomorrow night. I promise it'll be fun. Oh, and by the way, I'm working on getting a guest. It's probably going to happen at the beginning of the week. It's someone that is a big contributor to this channel, and they can talk to us about digital forensics. They are an expert in it. They have a career in it. And this individual actually offered to come on the show and explain that. I have some really great questions lined up for them. So I'm going to look at my schedule, and hopefully they said that they would be available at the beginning of this week coming up. So maybe Monday or Tuesday before I go back to work, we'll whip up a stream and we'll talk some digital forensics. And I think that'll be very relevant to, to the cases that we've been covering, especially Kohberger. It'll be able to explain how they extracted that information, how they got that evidence, how they looked through the processes of, emails and social media. This person's an expert in this area, and I think it's going to be really great to bring them on. So I'm super excited about that, and I will give you guys an update soon. I am being very active on my community page, so please go over to the homepage, click on that community tab. I've been doing a ton of updates over there. And also, if you haven't already and you're a new member to the channel, go on that homepage, scroll all the way down, and there's members only content. I'm going to be working on a new short film video soon. I have a script that's written. I need to start working on that. But I think this time, instead of trying to get pumping it out, I really want to work on it and craft it. And it is going to be, I'm not going to tell you what it is. I actually have 2 videos, short film videos in mind that I'm going to be working on. I just have to, I started working on one today and I just couldn't get into it, but be ready for those. And I'm going to craft those probably over the next couple of weeks. I don't want to rush to get them out. Okay. I'm going to hit one last kind of meme, and then we're gonna hit the outro and get out of here. I'll probably do some streaming tomorrow night. Geez, I didn't realize we were on for 2 hours. I just looked up and I was like, whoa, everybody's heading out of the chat. I'm rambling too long. And we'll work on getting something going here tomorrow night. All right, everybody be safe, be strong. Probably gonna do some TPG stuff tomorrow. And you all know how to get in touch with me. Just reach out to me, text me if you have my number. Let's Talk Live YouTube channel on Twitter. I'm sorry, YTC on Twitter. Let's Talk Live podcast at gmail.com, and LTL podcast on Facebook. And I also have an IG account that I've just got up and running, but I have not been paying attention. So it's ltl.podcast. You can find me over there as well if you want to connect. All right, let me do this, and then we're going to get out of here.
One, I'm young enough. 2, I'm confident enough that I'm always going to make money in something. If I gave up if I never sold another watch tomorrow, I could start selling paper cups, plastic cups, and I'll do good at it.